Good day, viewers. Once again, the name of our show is Understanding Law with Tabi, and I'm your host, Mrs. Tabitha Charlene Chikea. During last week's discussion, we talked about the various law reforms which are being made as regards the marriages in Zimbabwe. As we say, there is a proposed marriage bill which is going to alter how marriages are dealt with in Zimbabwe. And you realize from last week I said I'm going to be proffering solutions as to how we protect the properties that we would have acquired during the subsistence of our marriage. But I felt it wise for us to first talk of inheritance laws in Zimbabwe, vis the proposed marriage bills. So in Zimbabwe, you will realize that there are two types of inheritance. There is inheritance with a will, and there is inheritance without a will. The more legalist people call inheritance with a will testate inheritance, from the word testimony, and others call inheritance without a will intestate inheritance. You will realize that where there is a will, things seemingly become easier. So I'm going to talk first on inheritance without a will. In Shona, there is this common proverb which says, "Pfuma yenhaka inoparadza ukama." The reason why the Shona people brought this word "Pfuma yenhaka inoparadza ukama" is simply because where the deceased person does not leave out stipulated conditions on how his property or her property is supposed to be administered upon his death, they become a very big problem, because everyone wants to scramble and take the little which the deceased would have left behind. So the courts have come up with solutions on how to deal with the property which the deceased person would have left behind. And you will reckon that in order for us to understand how the various laws apply, we must understand the various marriages which apply in Zimbabwe. So for those who have not yet had an opportunity to listen to the series that we had on the various laws in Zimbabwe, please go to the page to the YouTube channel, Understanding Law with Tabi, and you will have a very unique understanding of the marriage laws as they apply in Zimbabwe. So you will see that in Zimbabwe, there are three types of marriages: the registered customary law marriage, the unregistered customary law union, and the civil law marriage. So I'm going to start with the civil law marriage. Let's say it is the husband who dies and he does not leave behind any will. How will the courts administer the property which the deceased person would have left behind? The deceased person's property is dealt with in accordance with the Administrations of Estates Act. So in administering the property, the courts say, number one, the surviving spouse is entitled to what is called the matrimonial home. It might seem simple, right? That the matrimonial home is the home where you'll be staying with your husband, so automatically you are entitled to that house. But keep on watching as I'm going to delve in more to what is the matrimonial home. After being entitled to the matrimonial home, the surviving spouse is entitled to a child's share of the free residue of the estate. Let me explain the terms a bit further. The courts say that the matrimonial home is the home where the surviving spouse resided prior the death of the deceased person. Please take note that the Act does not stipulate the time period. It does not give a stipulated period when the surviving spouse was supposed to be staying in the matrimonial home. It just says prior the death of the deceased person. So courts have gone further to interpret what this provision means. In the case of Ndoro versus Ndoro, in this case, there was a wife, Mrs. Ndoro, and the husband, Mr. Ndoro, he was ill, and for some time, I think he was ill for close to 2 months. And the wife was a teacher, teaching in Kadoma, and the husband was staying in Norton during all his illness. That was their matrimonial home. And during the tenure of his illness, medical bills started to accumulate, and Mrs. Ndoro could not afford to come back home and visit his husband frequently. Being a civil servant, the money was not sufficient. So she decided to sacrifice and to stay at her school-provided accommodation during the tenure of Mr. Ndoro's illness. So upon Mr. Ndoro's death, Mrs. Ndoro was staying at the school-provided accommodation. And you will note that Mr. Ndoro had other children from a previous marriage. So upon the death of Mr. Ndoro, Mrs. Ndoro went to register the estate, and she claimed the Norton house to be her matrimonial home. And the children said, no, this is not your matrimonial home, because you are not residing in that house prior the death of Mr. Ndoro. And the courts bought the argument which was proffered by Mr. Ndoro's kids. And Mrs. Ndoro was awarded what we call a child's share in the estate. So let's say, for example, if Mr. Ndoro had 6 children, Mrs. Ndoro would be counted as the 7th child, and she will be given a 7th part of the house, which means essentially she would be disinherited from a house. Maybe she would have bought using her own money as well, being a civil servant. Maybe they could have equally contributed to the house. But just because the title deeds were in Mr. Ndoro's name, it meant that the property per se belonged to the estate of Mr. Ndoro. So upon his death, she was given a child's share because of the interpretation of the word matrimonial home. And you realize, I say that upon being given the matrimonial home, there would be what is called the free residue of the estate. What is the free residue of the estate? The free residue of the estate is after we remove the matrimonial home and the household effects and the matrimonial car, the remainder of the property, which then remains also after paying what we call the master's fee, which is 4% of the entire estate, after paying what is called the estate duty, which is 5% of the dutiable amount, and after paying what is called the executor's fee, which is 4% of the estate. That's when, and also after paying creditors, if the estate had any other creditors, the remainder of the estate is what is called the free residue of the estate. And a wife who's married under Chapter 5.11, who is soon to be called a wife married under a civil law marriage, is entitled to a child's share of the free residue of the estate in the event that the husband dies without leaving a will. And the same also applies where it is the wife who dies and leaves the husband. The same laws apply where there is no will and where the property is registered in the name of the wife. And you will realize that for the purposes of inheritance, the civil law marriage is potentially polygamous. And last week on our interesting discussion, we said that a civil law marriage allows what are called civil partnerships. So in civil partnerships, let's say your husband is in a civil partnership and he buys a house and registers that house in his name, but he gives that house to his civil partner to stay in that house during the subsistence of their partnerships. And it so happens that the husband dies during the subsistence of the partnership. The civil partner is entitled to that house as it will be her matrimonial home, according to Section 3 of the Administration of Estates Act, which says that the woman is entitled, the surviving spouse rather, is entitled to what is called the matrimonial home, where she was staying prior the death of the deceased person. So you see there are various intricacies which come along with these laws that we have. And I'll give you a practical example which happened. Some of you who read in the media, in the newspapers, there was this interesting case of a woman who had her husband. When things got tough in Zimbabwe, the woman decided to go to the diaspora to work for the family. She was in the UK. So working for the family, they bought a house in Zimbabwe. The husband was still in Zimbabwe. And being a submissive wife, the wife had the property registered in the name of the husband. But the husband chose to have a civil partner or Other people might call them, in slang language, side chicks. And that woman began to stay with the husband in the house, which was bought using the money which the wife was getting from her job in the UK. It so happened that the husband died before the wife could return back to Zimbabwe. And in her argument, the woman who was now residing with the husband said that, no, this husband, he paid lobola to our family. I'm the legitimate wife to this man. And I was staying in this house, so it is my matrimonial home. And she won the battle. She was given that home. It was deemed to be her matrimonial home because she was staying in that house prior the death of the deceased person. So it does not matter how much the certain Mrs. X had committed, had invested, had sacrificed in the purchasing of this house. She lost out completely because of this provision. So others might be asking, after the matrimonial home is given, the free residue of the estate is paid, what then is next? Watch out for next week's edition, as we're going to be discussing further on what then happens after people are awarded the matrimonial home, you're awarded a percentage in the free residue of the estate. This is for next week's edition. For now, let's move on to people who are married under a registered customary law marriage. You will realize that this type of marriage is potentially polygamous, which means that in the event that the husband had multiple wives, each wife is entitled to the matrimonial home using the definition that we gave earlier on. So after being given your matrimonial home, all the other wives, let's say there are 3 wives involved, these 3 wives will then be regarded as one child when being given the free residue of the estate, which means no matter the number of the women who are involved, no matter the number of the wives who are there, they are all entitled to a child's share in the free residue of the estate. But the eldest wife is entitled to 1/3 of the one share which they are entitled to. So let's say, for example, there are 100 wives involved. Of the 100 wives, the eldest wife is entitled to 1/3 of their share, and the rest of the 99 other, they're entitled to 2/3 of the one share which they are entitled to. I hope I've made myself clear. So that's it. And when it's the husband, the same laws apply. We know that in Zimbabwe, a woman is not allowed to have more than one husband. And also in accordance with our custom, a woman cannot have more than one husband, which means essentially the husband, be it a customary law marriage, be it a civil law marriage, he is entitled to the matrimonial home and a percentage, a child's share in the free residue of the estate. So this makes it easier when it is the wife who dies first. But when it is the husband who dies first, there are complications which then arise, as we discussed earlier on. So the next question would come. Let's say I leave behind my will. Is my inheritance secure? Is it better, given what we have discussed prior as regards inheritance without a will? You realize that in Zimbabwe, wills in Zimbabwe are governed by what is called the Wills Act. And in accordance with the Wills Act, a will should satisfy the requirements of a will in order for it to be admissible as a will in the courts of law. Which means that when a will does not satisfy the formalities of a will, it ceases to be a will, and the inheritance is dealt with in accordance with inheritance without a will. Due to the length which inheritance with a will would take, next week we're going to discuss the intricacies of inheritance with a will. How is a will written? Can I have an oral will? Is it admissible in court? Can I have a will which is just maybe uttered just seconds before I die, is it considered to be a will in Zimbabwe? And can someone write a will on my behalf and that will be admissible as a will? And maybe in times of civil war, should I follow the specifics which are stipulated in the law for my will to be considered to be a will? How do we write a will? How do we keep our wills? And in the event that I die, who will take out my will and give it to the Master of the High Court, to the lawyer, to my relatives, to read out the will and to stipulate the requirements that I want my property to be dealt with? Let's tune in next week as we're going to be discussing more about wills in Zimbabwe. Have a good day.